Okay, like guys, I am not going to be on long. I'm just going to give you guys the information and then I'm going to get off. I promise you. I'm not going to stay on there, but I wanted to give you guys um this was my first time attending the YFN Lucci RICO trial. It's my first time. I am green. I don't know what's happening, and I'm just coming to it with a clean slate. Don't know anything. But what I can do is tell you the atmosphere, what happened in court, what the judge said, and what's going on forward. Okay. First, I want to tell you it's not as hectic as the YSL case. I'm going to tell you right now, it was smooth sailing, no issues, no extra security, and all that. But I do want to point out that the defendants were not in the courtroom, so maybe that is one of the reasons why it's more laid back than with the tight security. I mean, of course they had security, but it wasn't like that crazy security that goes on in YSL case. All the defendants was on the video Zoom. Two defendants are not in custody. Two defendants are not in custody. And in fact, they were on the screen. Like one was like in the store shopping or something like he was in the supermarket. And the other one, I didn't really see his video, but they said he was there. But the other one incarcerated inside their cell and things like that. All the attorneys was there. There was one that didn't have a representation, but they fixed that issue before we got off the Zoom. The judge was basically saying to them that they wanted to get this ball rolling with the trial. So he started asking each attorney whether or not they were ready. He would ask the state and find out who was responsible on the state side for the individuals in the case, right? And I found out the young lady who is in charge of the whole case, like Love is in charge of the case that we're doing with YSL. The person that's in charge of her name is Shaniqua Christian. She's for the state. So she's the one that is going to be the lead in the on the state side covering this case, right? What I did learn, what I'm really, this case is supposed to be, I'm going to read the indictments and everything. And I did pull up some the indictment information. Hold on, let me see what I got here. And I'm like, if this case is supposed to be double murders, why do we have people on bond? Okay, look at this. They got murders. They got racketeering. I mean, they have like gang. I mean, everything that YSL have, they have it here. And no one when YSL was allowed to have bond. And you remember, Farley is asking for Farley to get bond, and he never had a criminal record or anything like that. And he got charges because being part of knowing YSL and saying he's part of a gang. But two of these individuals on here are on bond. And you see this, and it started out with 12. It's down to 11 because one of the defendants, he took a plea. One of the defendants took a plea. So they have this case with 11 defendants on it, okay? And two of them are out on bond. Because I saw them outside. Well, I didn't see the other one. I just saw one. YFN has much more. Yeah, 13. Wait, 13, where have you been? You've been hiding out on me, 13. We got to talk. We got to talk, 13. We got to talk. Only one is trying to sever. They had a hearing after that, but I didn't stay because I didn't want to be stuck in traffic. So I just I left before they started to talk about the severance part. So my question is, why is it that Farley is not allowed to have bond? And I personally seen the guy outside in the store. One of them I didn't see. The other one I saw, he was in the store shopping. And he was on bond, y'all. He was on bond, and he's part of this racketeering. And they have multi murders on this case here, and they're charged with a gang. They charged with guns. They charged with, I mean, they charge with stuff that the other group is charged with, but they're not. You get what I'm saying? So I'm a little confused here, y'all. In fact, let me tell you, in fact, YFN was arrested before YSL. So, and let me show you the bond too. I'm not lying. I am not lying, y'all. I'm not lying. The argument they gave for the bond. Let me show you the argument they gave for the bond. Hold on. Hold on a second. Bond. Hold on. Do I have it in here? Hold on. Let's see. The argument they gave for the bond. Did I mess up and not pull out the right thing? Hold on. Okay, this is her argument for the bond. Let me go show you her argument for the bond. And I'm like, this is kind of weird here. Why isn't this other guy giving bond, but this guy's giving bond? Let me show you. This is the argument they gave. A motion for bond. It said, now comes defendant in the above style. This was done on November 4th, 2022. Okay. Now come in defendant in the above style action and respectfully move this court to set a reasonable bond therein. Defendant has consistently incarcerated at the Fulton County Jail. The defendant poses no significant threat of fleeing from this jurisdiction, of failing to appear in court when required, of committing any felony pending trial, of intimidating witnesses or otherwise obstruction of the administration of justice. The sheriff of the Fulton County Jail has admitted that he is unable to keep inmates safe, resulting in many deaths and serious physical injuries to many inmates. See? See? You see, y'all? That is what she said for the bond. Dun, 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 dun. Didn't somebody say there's a video of somebody getting hogtied and hold on a second. So don't you think the other people have a he did bring up the burner phone being used in jail discussing a gun. They're really trying to make the judge believe he is a criminal activity as well. And he should be granted the bond though. But you know what? It's not against the law to have a gun in Georgia. Georgia is a right to bear arms here. You know, everybody has a gun in Georgia. I'm not saying criminals should have a gun, but everybody has a gun. Okay. But and okay, I want to give you some more because I gotta get off this live. Okay. I told you there was some people out there, and this guy Hawkins is asking they want his case to be severed, and they did have a motion on that afterwards, right? And let's see, they asked, the judge was asking them the readiness of trial. Every single one of the attorneys says they will be ready for trial, right? And so he set the tentative date, which would be, and first they started out, it was going to be like, he gave them 2 months, August or October, right? But he was asking them to raise their hand of anybody who hasn't kind of conflict, and everybody had, most of them had conflicts in October, in the month, November, August. Most had conflicts in the month of August, but in the month of October, you had Mr. Findley, who, by the way, he's also Trump's attorney as well. He is Lucci's attorney. He has a conflict in October because he has a federal case he has to do in October in San Francisco. So he cannot be there for October. So then the judge gave him the month of January. No one objected to the month of January. So it's tentatively the January 2024 for trial to begin. The judge asked the state, how long do you think it would take? So the state says that they're going to have 500 lay witnesses, which is the 701 type of witnesses that just like facts and just not expert. They're only going to have 4 expert witnesses, and that's the 702 witnesses, right? And then the other one's going to fall in the other place, right? So they're going to have 4 categories that they're doing the expertise in. Those categories is gang expert category, ballistic GBI category, cell phone tower category, medical expert category. And then he asked the defendants, did they have any expert category they would like to add in along with what the state had already said. So 2 of the attorneys says they have the human factor expert category and the accident expert category. So the defense has 2 type of experts that they're gonna bring in. So the state said that the case, they think it was going to be 5 months, right? The judge was asking, why 5 months? Why? What is your reason for 5 months, right? And they was basically saying because of the amount of witnesses they have, that's why it's going to be 5 months. So then the judge asked the defense, how long do you think the trial is going to be? Most of the defense was like about 4 weeks. Another one says about a month and a half. So the judge is doing the case 4 weeks in the month of January, tentatively 4 weeks in the month of January. Okay. All right. So, let's see. Then Mr. Findley had offered to help by doing the draft of the juror questionnaire, but then the judge says that's already been done. They're ready because the judge is ready to go. He just said he's basically has to hurry up because they want this trial to begin, because this trial has been like postponed so long that it's time for it to get rock and roll. Basically, he got to rock and roll. He's being pressured to get this trial started, right? Then he tells them that they're gonna have to submit trial. What was the word? Trial. There's a word he used. Trial brief. That each side has to submit the trial brief. So he gave the state 45 days to submit their trial brief, and that trial brief is going to give a reason why they believe they should have the 500 witnesses, right? What is the purpose for those 500? So, and that's going to be done under seal because they said they don't want people named, the list of witnesses. They don't want nobody to be tampered with, so they're going to keep that hush hush. So it's going to be under seal. Okay. There is a motion for sever, which is the guy I was telling you about, which is the guy Rodriguez Hawkins. He's they're asking for his case to be severed, right? And there is a motion out there. There is a motion in regard to some guy gave some information about the other defendants, and they're trying to keep that from coming out. So there is a motion on board about that. Hold on, let me just pull it up for you guys. I'm not going to read it, I'm not gonna read it because I want to get off. So I'll probably read it. I'll read it tomorrow. I'll read it tomorrow. But today I got to get off this live because my husband's home and I got to get down there and cook. I didn't do the tacos, y'all. So I got to get off this thing here. But remember, the date that he gave is possible date. It's not committed. It's not concrete. It's penciled in. It's like save the date type of thing because you don't know what could happen. But he asked the defense and the if he asked both sides 3 times, do you have anything that will cause you not to be here in the month of January? And everybody said it was okay. The day was all right. All right. So any questions? Because I'm about to get off. Any questions? Any questions? Well, you know what? I would love to read what this thing says for you guys to help you guys to see what this person said. Okay. It's called state motion for order declaring the statement admissible against all defendants. So that means somebody told on all defendants and they want to bring it up in there. Okay, I'm gonna read it for y'all. I'm gonna read it. I'm gonna do it quick. I'm gonna do a quick read and then I'm gonna get off, okay? I'm gonna do a quick read. I'm gonna get off, get my butt off of here. Okay, hold on. No, this is YFN. YFN. Okay, hold on. I'm gonna do this. I'm gonna read this off for you. Hold on. I'm gonna try to read it quick as possible. It's supposed to be really fast. Okay. State's motion for order declaring statement admissible against all defendants. Now comes the state of Georgia by and through undersigned district attorney and filed this motion for order declaring statement admissible against all defendant. Okay. Introduction. The state has obtained various text messages, communication, and communication and recorded jail telephone calls. Oh, they got jail telephone calls on them too, y'all. Calls made by some of the defendant and other associates. These statements are relevant and they are not hearsay because they are admission as a party's own statement and as co-conspirators' statement. Even if they are hearsay, they are admissible as statement against interest. Finally, that are not subject to confrontation clause because the statements are not testimonial in nature. Y'all hear that? The state seeks a pretrial order of these statements admissible at trial against all defendant so that the state may exercise its appeals right should this court issue an adverse ruling. In support of this motion, the state shows the following. I'm not going to read 11 pages, y'all. I'm going to read a little bit and then I'm going to stop. The defendants are associates of the blood criminal street gang and are indicted for violation of a Racketeering Influence and Corruption Organization Act, RICO, count 1. Dozens of the violation of the street gang Terrorism and Prevention Act counts and other felonies. During its investigation into the defendant's crime, the state obtained numerous recorded jail telephone conversation and text messages, communication between the defendants and all of the other Bloods associate. You know what, y'all? We're going to read this another time because I don't feel like reading it now because Rhino's downstairs. I got to go, y'all. I got to go. Save it for tomorrow, okay, guys? All right. I'll see you later. Bye. Bye.